welcome everybody to the first of the 3 training sessions. My name is Stephen O'Reilly. I'm a partner in the charity and social enterprise team here at Hempsons. I'm relatively new to Hempsons. I joined at the start of the summer, having spent 12 years latterly as a partner and head of the charity team at Evershed Sutherland. And I'd like to welcome you all today to the session where we're going to be looking at the legal duties and responsibilities of charity trustees. I know many of you are trustees, so hopefully you'll find it beneficial. Okay, so let me give you an outline of today's session. First of all, we're going to talk about structure and terminology, because a number of terms are used. Very often they mean the same thing, or they mean slightly different things, and it's also always helpful to have an explanation of what they mean and to understand what you are when you're referring to yourself in a particular capacity. Then we're going to move on to duties and responsibilities. Then we're going to consider investment powers, and we're going to touch on the important matter of managing conflicts of interest. And this is an area that the head of legal at the Charity Commission recently said was one of the biggest issues facing charities in the sector. And finally, we're going to briefly mention recent developments in charity law, so a brief charity law update. Indeed, there has been some new guidance released by the Charity Commission today, which we will touch on. So structure and terminology. Charities, people are often confused and say, well, I'd like to set up a charity. Well, what does that mean? Charity itself isn't a legal structure, so you need to decide on what sort of entity you're going to be in the first place. Now, many charities have been in existence for a long period of time. They might be Royal Charter corporations, or they might be charitable trusts, because historically most charities were established as trusts. The charity might also be an unincorporated association, which has got members who are involved in the governance of the charity. It can also be a charitable company. There are also other terms I haven't included there, like CIOs, charitable incorporated organizations, or community benefit societies. A number of these organizations can be charities. They can also, some of them can be non-charities. For example, a company can be a non-charity, and a trust can be a private trust. It can be a non-charitable trust. And some of these organizations can only be charities, for example, charitable incorporated organizations. So it's important to understand what legal entity you're talking about when you're referring to a charity. Your organization will be something first, and then it will be a charity. So that's absolutely key to understand. Then we talk about, well, who's involved? Who are the participants in this legal vehicle? Who plays a part? Now, of course, this training session is for charity trustees, but charity trustees often have a number of different names. They could be called council members. They could be called the council of management. They could be called the executive committee. They could be referred to as directors. Now, it's not incorrect if you're a charity trustee of a charitable company to refer to yourself as a director, because you are both a director and a charity trustee. And I'll touch on the sort of slight differences in the duties of directors and charity trustees later. But it's important to understand the different terms that are used, and you might want to explore the position in your organization, maybe referring to the governing document and or the terminology that's used in your organization. And then you also sort of, once you understand the different names being used, you can understand the governance structure of your organization. So are there members? For example, a company limited by guarantee will have members and will have directors. So there's a two-tier governance structure. And that's common in unincorporated associations and also in CIOs. So you might have a group of members that elect the trustees. That's not the case in, for example, a charitable trust where you've got just charity trustees. They are the only participants in the governance structure of the organization. Confusingly, you can also adopt sort of almost like a single tier of governance in a charitable company where the only members of the charity are the trustees from time to time. This is also possible in the CIO structure. This is known as the foundation model of governance. And when you set up a charity, it's the Charity Commission, for example, has a set of model governing documents. And for charitable companies, it has two options. You have an association model, which anticipates a wider membership electing trustees. And it also has a foundation model of governance, which is considered to be administratively more convenient. And that is a model of governance where the only members are the trustees from time to time. So in addition to understanding the terms that are used, it's also important to understand the governance structure that your organization operates. I think it's always helpful to think, well, okay, well, what is a charity? As I said, charity doesn't denote legal entity, because you have to have a legal entity first. The legal definition is an institution which is established for charitable purposes only and is subject to the control of the High Court's charity law jurisdiction. So the Charities Act 2011, in one of the early sections, sets out a number of charitable purposes. Most common we would think of is the advancement of education, the relief of poverty, the advancement of health and saving of lives, the relief of sickness. They're the sort of some of the key charitable purposes. So a charity must have a set of objects or purposes, and they must fall within the description of purposes set out in the Charities Act 2011. So do you know what your charity's purposes are? What are the objects? Where would you find them? Well, you find them typically in your governing document. They would be very close to the beginning of your governing document, and you can find them there. Some charities are statutory corporations, and they might have their objects set out in a piece of legislation. So it's important to understand what your objects are. Now, the charity test is two-limbed. You have to have a charitable purpose, a set of objects, and you must act for the public benefit. So for some charities, that's self-evident, but when charities are making an application for registration to the Charity Commission, you need to satisfy the public benefit requirement. So who are charity trustees? Well, there's a definition in section 177 of the Charities Act 2011. They are the persons having the general control and management of the administration of a charity. Drilling down to that in a little bit more detail, they're generally unpaid volunteers. They have strategic oversight, not day-to-day control. Think of yourselves as charity trustees, almost like non-executive directors in a commercial environment. They're not typically part of the executive team or senior management team. They act collectively. They're distinct from senior staff, employees. Importantly, they have independent control over and legal responsibility for the running of the charity. There's typically a limit on a number of consecutive terms that a trustee will act for. So what does that mean? Well, good governance generally dictates that you serve for a number of terms, and there is a limit on the number of terms that you may serve for. For example, you may be appointed as a trustee for a 3-year term. You might be allowed to be reappointed once or possibly twice, and then maybe in exceptional circumstances for a further term. So there may be a limit of 6, 9, or 12 years in office. It's considered good governance to refresh the board regularly, and having terms of office in this way helps with that refreshing of the board. Trustees are also required to act independently regardless of those who appoint them. We often see mistaken assumptions from trustees who think, well, I'm a delegate of X. They have appointed me, therefore I owe a duty for them and must represent them on this board. Well, that's not right at all. You need to leave the interests of your appointer at the door when you enter a trustee meeting. Your duty is to act in the best interests of the charity, regardless of who appoints you. Moving on to trustees' duties and responsibilities. We're going to break this down into 6 different sections. So the primary duty, then acting in the charity's best interests, thinking about terms that are used when it comes to trustees' duties, such as skill and care, what you need to do practically when you safeguard property. And I'm going to touch on a little bit of detail on investments and the duties that relate to investments. And then we'll just deal with statutory duties in a little bit more detail. So your primary duty is to comply with the governing documents. Now, that might be singular or plural. For example, if you're a Royal Charter Corporation, you might have a Royal Charter, and the Royal Charter doesn't say an awful lot in it, apart from maybe your objects, and set out some powers, but there might be bylaws and regulations as well. So you need to understand in the first instance, what is your governing document? Have you got a copy of it? Where can you find it? Have you got the most recent version of the governing document? On appointment as a trustee, you should be provided with a copy of the governing document by the charity. So, for example, if you're a trustee of a charitable company, you can download the Articles of Association, the governing document of the charity, from Companies House. It's a bit more difficult when you're a trustee of a charitable trust or a CIO, because the Charity Commission doesn't have a register, an up-to-date register of governing documents and other documents in the same way as Companies House does. They don't have the resources to have a publicly available register. So it's important that you ask for and receive a copy of the governing document. You also should cross-check that with records held at Companies House, for example, if you're a trustee of a charitable company, and the Charity Commission. So is the document that you have the most recent version? Because what the Charity Commission does record is the detail of the most recent version of the governing document that it has. Now you want to check that you have the most recent version, or indeed that the most recent version has been filed with the relevant regulator. Okay, you've got the governing document. You need to understand in advance the purposes of the charity. Well, what are the purposes? Purposes are, the term purposes is used interchangeably with objects. So you look at the objects of your charity and you say, well, okay, do I understand what that means? Very often, objects will be drafted in a particular way, and they might sound archaic. There may be a good reason for the use of particular language, but do you understand what the objects are, what they mean? You might want to consider updating your objects if they haven't been updated in quite some time, although that typically requires Charity Commission consent, which they may or may not be willing to give you in advance. You need to make sure that what your charity is doing furthers your charitable purposes and nothing else. So the activities that you undertake, do they fall within your objects? That's a key question, because if they don't, even if the activities are themselves charitable, the charity could potentially be acting ultra vires by undertaking activity that falls outside of its objects. This could lead to issues for the trustees and potentially also tax consequences. So it's important that the activities that you undertake fall within your objects only. There's a term that's often used mission drift, which is where a charity was set up some time ago, undertaking certain activity, and expanded that activity. A good example of this is a charity that's set up to advance education in London, and over the years has decided, well, there's a great opportunity to advance education in Birmingham, so we've engaged in a fantastic charitable educational activity in Birmingham. Well, that's an example of mission drift, because the objects don't permit the advancement of education in Birmingham, only in London. So potentially the activity is ultra vires. So you need to just not only familiarize yourself with your objects, but understand your objects in the context of the activities that you carry out as a charity. Your overriding objective or guiding principle, it's the sort of terminology that's used here, is as a trustee, you must act in the best interests of your charity. That's the key duty. So when you're making a decision, you go through an appropriate decision-making process, and we'll touch on that in our second webinar in this series. But at the end, you must say, is this in the best interests of the charity? Is this decision in the best interest of the charity? Let's leave aside all of the other issues. Have we acted in the best interest of the charity? Not in the interest of somebody who's appointed me, not in the interest of the staff, not in the interest of the trustees. Is this decision in the best interest of the charity? So what do you do? Well, you should take into account appropriate factors, and we'll touch on this decision-making process in a little bit more detail. Unhelpfully, the Charity Commission's guidance also says you should not take into account inappropriate factors. I mean, surely that's self-evident, but that is the guidance as laid out. You should not profit personally. Any benefits should be authorized. Now, I'll go into this in a little bit of detail, because this is a serious area that can trip up charities and their trustees from time to time. So what's allowed? Well, charity trustees should not profit from their office unless this is authorized specifically by the governing document, statute, the general law, or a regulator. And by a regulator here, we mean the Charity Commission. The safe position is to assume that trustees serve in a voluntary capacity and should not benefit from their charity. So fewer than 1% of charities have got a power to pay their trustees for acting as such. It's pretty rare that you get charities that pay trustees for acting as such. Okay, so just drilling down to this in a little bit more detail. The governing documents of charities usually contain a range of standard permitted benefits. For example, receiving reasonable rent. There are also certain powers that are set out in the Charities Act that enable a trustee to be paid for the provision of services or goods related to the provision of services. You're of course allowed to be reimbursed for out-of-pocket expenses which were incurred on charity business and evidenced. So they need to be reasonable expenses. Well, what's reasonable? Is it proportionate for you to take a first-class train to a trustee meeting, or stay in a particularly grand hotel in London for a trustee meeting? Everything needs to be proportionate. When charities come to me and say, well, we do have a power to pay a trustee in these circumstances, you really need to think, well, okay, we've got a power to do that. For example, we've got a power to pay a trustee for acting in their professional capacity. Well, how does this look from a reputational perspective? Is there a significant benefit in engaging, for example, a trustee surveyor's firm to provide you with advice in respect of a particular property transaction? Or would it simply be better to seek that advice from elsewhere? Is there some significant advantage or benefit to the charity for example, reduced fees or particular expertise that this firm has that means that you should instruct that particular trustee's firm. And of course, conflicts of interest should be managed. It's that's something that we're going to touch on a little bit more detail later on. So paying a trustee for acting as such is distinct from the powers typically set out in a charity's governing document to pay a trustee in certain circumstances, which are narrow and tightly construed. There may rarely be a power to pay a trustee for acting as such in a governing document. More likely, you would go to the Charity Commission and get consent for the power to pay a trustee. And if that happens, the Charity Commission likes to give a time-limited power and set out the maximum amount that can be paid. So I did a lot of work in the further education sector a few years ago, and there were a number of mergers taking place. So trustees had to undertake quite a lot more work than they had done previously. So it was not uncommon for a chair of a further education college to be paid for a 6 or 12-month period for acting as chair to guide that particular institution through a merger process. So that's an example, but the time, it was time limited, and the Charity Commission prefer you to come back to them to say, well, can we extend that time period in which we can pay a particular trustee rather than giving you a blanket power to pay trustees. Also, watch out if you've got a trading subsidiary and you have trustees sitting on the board of the trading subsidiary, you can only remunerate them for acting as a director of a trading subsidiary if there's a power in the governing document of the charity. The Charity Commission is quite clear on this. Its guidance says putting a trustee on the board of a trading subsidiary should not be used as a method to pay a trustee by the back door. So that's just something to watch out for. I've seen people who thought they were quite clever in the past putting a trustee on the board of a trading subsidiary and paying them. It's not so clever when the auditors work it out and say, well, where is your power to pay this trustee who's sitting on the board of a trading subsidiary? Okay, so moving on to exercising reasonable skill and care. Now, forgive me with the definitions here because they've all been established by some legal case in the dim and distant past, but I'll try and unpack what the definition means for you. So what is the standard of skill? Well, it's a degree of competence which could reasonably be expected of someone with your degree of knowledge and experience. Lawyers like the word reasonable, don't they? Because nobody really knows what it means. But what is someone of your degree of knowledge and experience? To give you an example, if you're a qualified accountant, there'd be a higher level of financial understanding expected of you as an accountant. Or if you're dealing with a property transaction and you're a surveyor, there's a higher, you would be expected to have a higher understanding of the property market. Moving on to the standard of care, that's the degree of care a reasonable person would exercise on their own behalf. So what would you do if you were faced with that particular situation yourself? What degree of care would you exercise? Ultimately, you need to be active as a trustee. You need to ask questions. You need to interrogate your executive team. We're entering into a transaction. Why are we entering into this transaction? What are the best? Why is this in the best interest of the charity? What has led to this conclusion? Now we will, as I said earlier, touch on this in a little bit more detail in our second webinar. But you must be active. You must make inquiries. Don't assume that a question is too simple or straightforward to ask. Very often people disappear down a rabbit hole and start thinking about complex issues, whereas they just need to step back and think, well, why are we doing this in the first place? Charity trustees can be criticized, but they're more likely to be criticized if they don't apply their minds to a decision-making process. If they go through an appropriate decision-making process, they're far less likely to be criticized, even if in hindsight, the decision looks like it wasn't the correct decision to make. Everybody can make mistakes, and that's acceptable. As trustees, you must manage and safeguard property. You must protect the charity's assets. You must maximize your assets for charitable purposes, i.e. the objects. So let's talk about that. Well, what does protecting assets mean? It's always helpful to give a couple of examples. Well, protecting assets means if you've got a property, you make sure that that property is insured and insured with a reputable insurance company. You must maximize your assets for the charity's purposes. Well, what does that mean? Well, if you've got a significant level of funds, where are those funds? When are they required? Should they be invested? Are they sitting in a current account at a bank? Should they be invested with an investment manager? Because they're not being maximized if they're sitting there earning interest at 0.2% at a high street bank. So I've touched on protecting assets and I've touched on maximizing assets for your charitable purposes. It's also important to identify and mitigate any risks that your charity faces, and that will, the key risks should be set out in the risk register. Understand who's responsible for maintenance of that risk register and when it's updated. Is it a standing item at board meetings, or is it something you do on a quarterly or annual basis, or as circumstances change? Clearly, it's important to understand the solvency of the organization and continued effectiveness. Different rules apply to you depending on your legal form, but particularly if you're financially minded, interrogating the most recent set of accounts and sort of financial management reporting is absolutely key. And finally, do you know what your assets are? You understand? Have you looked in your accounts? Do you understand what they are? A good example of assets that aren't protected properly are intellectual property assets. Very often, a charity will have very valuable IP, as it's typically known, but that IP may not be protected. For example, have you got a trademark? Is that trademark protected with the trademark registry at the Intellectual Property Office? We often find that charities haven't protected their assets in this way, which can lead to confusion and ultimately somebody else registering a trademark with a similar name and or logo. I touched on the standard of care, and I thought it would be helpful to look at the standard of care in the context of the duty to invest, because the duty to invest is one of the key duties that trustees have. So let's bring that to life a little bit. Well, what is the standard of care when making an investment? The standard of care is that which a prudent business person would observe in making investment decisions on behalf of people for whom they feel morally obliged to provide, for example, a parent to their children. It's not the standard of care you might feel when making a decision in respect of investments yourself, because you might say, well, I'm going to take a risk here. It's the standard of care you would feel if you're morally obliged to provide for somebody else. So you might be less risk averse when taking a decision in respect of your own investments. That's an important point to consider when acting as a trustee and the standard of care that you must adhere to when making investment decisions. I think it's also helpful to understand what we mean by investments. So investments are split into two types. The first is a pure financial investment and is what we would understand an investment to be. In practice, charities do not spend all of their resources on their purposes. Some are lucky enough to have additional assets, and they will choose to invest those assets. So what is a pure financial investment? A pure financial investment is an investment that is aimed at securing the best financial return given the level of risk. So you might be in a charity with an endowment fund, and you'll say, well, we don't need some of this money for 2, 3, 5, 10 years. So we've taken advice and we think that we can make an investment in a particularly risky asset class, provided that we have a generally balanced portfolio of investments. That is discharging your duty when looking to seek the best financial return. The Charity Commission has some quite detailed guidance on duties and the standard of care when charity trustees are making financial investments in their recently updated publication CC14. Now, the second type of investment is a social investment, which confusingly is not really an investment at all. It is something that was set out in statute, the Charities Protection and Social Investments Act 2016. It is an investment with a view to both directly furthering the charity's purpose and achieving a financial return for the charity. The rules are similar to a charitable application of funds rather than actually an investment. So you might say, well, going back to my earlier example of a charity that's advancing education in London, you might say, well, yeah, okay, there's this great initiative being run by another charity. So we're going to make a loan to it or invest in this initiative in some other way, and we're going to get a return, because at the end of the day, we're going to receive our money back at the end of the particular project. We don't need to make a market rate of return, but we're going to see some return. And that's what a social investment is. It's different to a grant where you might receive nothing in return, but it's something that you might make some return on. Okay, statutory duties. What are those statutory duties? Well, they're set out in legislation. So the Charities Act 2011 is the principal source of charity legislation. Unfortunately, charity law doesn't set out, every provision of charity law is not set out in the Charities Act 2011. The sorts of things that are dealt with are an obligation to prepare accounts and return information to the Charity Commission. So there's an obligation to prepare an account and return on an annual basis. You're also required to update the Charity Commission when you change your governing document, you change your name. It's good practice to update the Charity Commission as soon as trustees change. And there are restrictions set out in the Charities Act when it comes to dealing with assets. For example, when you're disposing of charity property and or mortgaging charity property, you need to comply with certain requirements. On a disposal of charity property, you're required to get a report, typically from a surveyor, and the trustees are under an obligation to obtain and consider that report in advance of disposing of charity property. In the same way, when mortgaging charity property, the trustees are required to obtain and consider advice from somebody they consider sufficiently expert in the area to provide advice to them on the details of the mortgage. Now that can be, for example, the finance director at the charity, or indeed one of the trustees, or it could be somebody independently commissioned to provide that advice. I said I would touch on the distinction between company law and charity law in a little bit of detail. The Companies Act sets out statutory duties that directors of companies are obliged to comply with, and it's pretty clear. There are about 8 sections of the Companies Act that deal with the duties of company directors. Unfortunately, the Charities Act doesn't set out those duties. It would be very helpful if at sections 10 to 17 of the Charities Act you had those duties laid out for you. The problem is the charity law has developed over quite a long period of time, and the duties developed as a result of trust law, for example. So the duties are not codified in the same way as the duties of company directors. But if you're a director of a charitable company, it is likely that in discharging your duties as a company director, you're likely to be discharging your duties as a charity trustee, because there is significant overlap between the duties of charity trustees and company directors. There's some areas where they diverge a little bit, and I'll come on to that in a bit of detail with conflicts of interest shortly. But to give you an example, Section 172 of the Companies Act sets out the key duty of a company director, and that is to act in the best interest of the member, or the members. But as a charity trustee, you don't act in the best interests of the members. You act to further the charity's purposes. So actually, the Companies Act is modified for charitable companies. So it says Section 172 is modified so that you act in the interests to further the purposes of the charity, rather than in the interests of the members or shareholders, as you would in a commercial company. So it's important to understand what your charity is in terms of what legal vehicle it is, legal entity it is, and to understand what duties you are then subject to. There are other statutory duties that may apply. As I touched on, Companies Act, there are Companies Act filings. So if your charity is a company, there are requirements to file with Companies House, and indeed the Companies House has a power to fine for late filings in a way that the Charity Commission does not. There are also requirements in relation to general meetings. For example, there's a statutory power to remove a director pursuant to Section 168 of the Charities Act. And there are insolvency rules which apply to charitable companies. I said I would talk about conflicts of interest in a bit of detail. This is a really important area for trustees to be aware of. So a number of years ago, the Charity Commission updated its guidance on conflicts of interest. So they came out with a definition, which is as follows. A conflict is any situation in which a trustee's personal interests or loyalties may prevent them from making a decision solely in the interests of the charity. Now, this definition isn't set out in any particular legislation, but it's set out in the Charity Commission's guidance on conflicts of interest. So what should we look at in this definition? It's pretty widely drafted, isn't it? If you just pick out a few terms, it's the definition says may prevent, and it says any situation. That's pretty wide. It doesn't have to prevent, it may prevent. Well, is that, a reasonable person considers that it may prevent? So it's always prudent to err on the side of caution and to over-declare interest rather than to under-declare, because you want to avoid any appearance of impropriety. So A conflict of interest might be a direct financial gain or an indirect financial gain. And please also note that it relates to persons connected to a trustee, and this term should be construed widely. So family members, business partners. There are a couple of definitions used in the Charities Act 2011, but if you're unsure, do declare, because you're not going to be criticized for over declaring. If you fail to declare, that's when you might find yourselves in difficulty. Now, I deal with a particular type of conflict of interest that is quite prevalent in the charity sector because of the nature of the people involved in the sector. They might be involved in a number of different organizations. So the Charity Commission's definition of conflicts of loyalty is as follows. There's a particular type of conflict of interest in which a trustee's loyalty or duty to another person or organization could prevent the trustee from making a decision only in the best interest of the charity. Again, let's unpack that definition. You could prevent, the situation could prevent the trustee from making a decision. It doesn't have to, but it could. If a reasonable person believes that it could. So we need to think about that when we're making declarations. A couple of examples of conflicts of loyalty are charity trustee has another role. For example, they're an employee of a funder of the charity, or they're an employee of a company providing services to the charity, although do bear in mind what I said earlier about a charity seeking to purchase services from a company where a trustee is a director or an employee, or you're a trustee of another similar charity in the same area, and you might be competing for funding. So what do? You've got a conflict of interest. Well, there's a general obligation to declare, avoid, and take action in relation to conflicts of interest. So I find it helpful to categorize conflicts of interest. And I've done that, and I've set out 5 different types of conflicts of interest below. First of all, the conflict is minor and the trustees use powers to allow the conflicted trustee to remain and vote. Well, where will those powers be? The powers will be in the governing document and or in a conflicts of interest policy that the charity operates. So you need to ask yourself, well, where is our conflicts of interest provision in the governing document, and where is our conflicts of interest policy? When was it last updated? If you're declaring an interest, where does it go? Well, there's a register of interests. Who's responsible for that register of interests? How frequently is it updated? Is there a standing item at board meetings reminding us to declare interests? For example, if your role as an organization changes, you should update the register of interests. If you move employment, you should update the register of interests. Okay, the second type of conflict is the conflict is minor and the trustee can remain present but not take part in the decision. So the trustees come to a conclusion that it would be helpful to have this trustee remain present because of their particular expertise, for example, to inform discussions, but they shouldn't be present in the decision-making process. The next category is, well, okay, the trustee is really conflicted here. So we'll allow them to attend the meeting, but when this particular item is under discussion, they should withdraw from the meeting. We'll make the decision and then we can invite them back into the meeting. The fourth option is, well, this conflict is serious enough to warrant the steps being taken by the board. What steps do I mean? Well, you might have board papers that we don't send to this particular trustee because of the conflict. We don't want them to gain some sort of knowledge or inside track into this particular matter. So they don't receive the board papers. They might not attend that particular board meeting. And finally, the conflict is so serious and ongoing that the trustee should resign. That's rare, but it does happen from time to time. So that's the kind of the sort of Armageddon scenario where the person can't continue to act because of serious conflicts. And always remember, there needs to be a sufficient number of unconflicted trustees to make a decision. I said that we would deal with the charity law update. So Charities Act 2022 came into force. It amends but doesn't change the fundamentals of charity law. It's essentially aiming to make regulatory procedures easier to administer by charities, and there's been a phased implementation. Most of it's enforced now. For example, in respect of some property transactions, it doesn't require you to get the advice of a surveyor before entering into the transaction. There was a feeling that the costs were unnecessarily prohibitive in those circumstances. There are also certain powers that enable you to change the charitable purposes of certain unincorporated charities more easily that have been brought into force, and indeed change the governing documents of charities more easily. We've taken advantage of a couple of those powers, but they tend to be at the margins rather than making fundamental changes to charity law. Really the key act when you're looking at charity law is the Charities Act 2011, and there hasn't been an overhaul of that act, and there may well be in the coming years, but that is the fundamental statute from a charity law perspective. The Charity Commission has in the past sort of year released guidance on charities and the use of social media, which is worth having regard to, or at least ensuring that somebody in your organization has regard to. And as I mentioned earlier, they have some updated guidance on investing charity money. So CC14, that's the duties when you're making investments. There's also a legal underpinning to that guidance, which goes into the case law underlying the guidance. Essentially, it goes into quite a lot of detail. And today, the Charity Commission have just updated their guidance on trustee decision making, which we will deal with at the next webinar. This guidance was referred to by a lawyer at the Charity Commission when I was dealing with a transaction there as the Charity Commission's most important and best guidance. And the lawyer was very keen for charity trustees in the transaction I was dealing with to follow that guidance in quite a lot of detail, given that it was a very important decision in the life of that charity. So what's next? What comes next? Well, this is session 1 of 3 sessions dealing with charity trustees and what they should have regard to. The next session is about making governance work better at board and senior management level. It's essentially bringing to life the duties and responsibilities that we've just been exploring today. So how does this work in practice? We'll look at trustee board effectiveness in greater depth. And we'll look at, well, how does the senior management team or the executive team, how does their work relate to that of the board? What is the role of the chief executive here? What about other people? Should they be attending board meetings? What is efficient delegation? So I said earlier, you should consider yourselves akin to non-executive directors in a commercial company. You don't have the time to be involved in the day-to-day decision making very often, so you need to delegate effectively. And finally, we'll touch on how to approach taking difficult decisions, which is often where we are asked to advise. So those are the areas we'll touch on in our next webinar on the 17th of September, and we hope to see as many of you as possible at that. I'm sure we have some questions, so if you just give me a moment, I will have a look at those, some of those questions, and try and let's pick out a couple of those questions, and I'll read them out to you for the benefit of those who will be listening to the recording of this. So I've got one question here. Isn't there an inherent difficulty for trustees in that they have legal responsibility for the running of the trust, but don't get involved in the operation of it? How can they know whether, for example, the risk register is being properly maintained without inquiring into the detail of how the executive is functioning on the ground. Well, I mean, going back to the point that I made earlier, be curious, make inquiries. You are ultimately responsible for the running of the trust, but you make reasonable inquiries having regard to your position as a charity trustee. Of course, you can't know the detail of everything that is going on, but requiring explanations of the executive staff rather than just taking things at face value will help you to get a better understanding. You can't understand the minutiae of everything, but it's always asking questions, and maybe sort of taking practical steps like attending the offices of the charity on an annual basis for a day to understand how things work, having an opportunity to ask more junior members of staff if there are any particular areas of concern that they have. So it's not there's not an exact science, but there are a number of things that you can do to help discharge your duties. Does the Charity Commission need to give permission for payments to church trustees, and in what circumstances? So the answer to that is, let's draw a distinction between payment for services and payment for goods that's permitted under the Charities Act, and provided that your governing document doesn't prevent that payment. So the example of the surveyor that I gave earlier, that is generally permissible. You might have a question as a bunch of charity trustees as to whether that looks good from a reputational perspective, but in those circumstances, there is likely to be a power to pay. Where you don't have a power to pay is you don't have a power to pay a trustee for acting as such. So for acting as a trustee, that's unlikely, or for paying a trustee as an employee of an organization. Again, there are a number of charities which do have the power to pay a trustee. If you think of a vice chancellor of a university, they are sit on the board and they're also remunerated. You think of a principal of a further education college, they are on the board and they are remunerated. A number of charities do have the power to remunerate. It's typically, yes, in answer to your question, typically you need to get permission of the Charity Commission because you need to be relying on some power. Now, the Charity Commission might give you a power to amend your governing document, might give consent to amend your governing document to include a power to pay your trustees. It will typically be one or two trustees, but they prefer to give a power by way of an order that is time limited and limited in amount. So you might say, well, you can pay a trustee for acting as such, and you can pay that trustee for 2 years and you can pay them £10,000 per annum, provided that you make a case to the Charity Commission. There is some quite detailed guidance on this. For how long will a volunteer serve with the trust? I don't quite understand that question, but if it's a question about terms of office of a trustee, typically trustees serve 3-year terms. As a matter of good governance, they may be capable of reappointment once, possibly twice, maybe 3 times in exceptional circumstances. But as a matter of good governance, it's important that the board is refreshed regularly. Okay, do the same roles, responsibilities outlined today apply for corporate trustees? The answer to that is yes. The corporate trustees are subject to the same duties. So hopefully that's pretty clear. In addition to the duties outlined and discussed, what additional duties and responsibilities apply to the chair of trustees? Well, the chair of trustees is subject to the exact same duties, but when it comes to running board meetings, for example, they don't have necessarily additional duties, but they are responsible for running and ensuring the smooth running of charity business. And very often they are seen as a figurehead of the charity. Thank you, everybody, very much for attending today. And should you have any questions, please do feel free to get in touch. And if there's anything else that you would like us to talk about in the future, please let us know. Thank you all.